What's a brief? In a criminal case, sometimes motions are filed, and when a motion is filed, a judge has one of two options to tell the lawyers what to do after we argue it. So once a lawyer files a motion, let's say it's to try to get the case thrown out for an illegal traffic stop or a search without a warrant or a bad search warrant or what have you. After the testimony is had in court at that suppression hearing, the judge will order the parties either to orally argue it, which means the lawyers just stand up and argue it right there, or to brief it, which is usually more common. And briefing it means written arguments that are submitted to the judge. And usually the order goes like this. The defense, if they're bringing the motion, we have to write the first brief. So first we file what's called a notice of motion to suppress, meaning that we're putting the court and the prosecutor on notice that we want to try to suppress evidence because we believe that your constitutional rights were violated. So that notice has to be filed well in advance. And then the court sets a hearing called a suppression hearing usually. And in that suppression hearing, or sometimes it's called a contested omnibus hearing in Minnesota, or even what's called a Rasmussen hearing. At any rate, and this happens in federal court too across the nation, the lawyers then have to brief it. And so we'll call that a memorandum of law or their suppression memorandum. And we file a big old long brief. Sometimes it's 5 pages long, other times it's 80 pages long. It just depends on the nature of the case, citing all of our legal arguments. And in that we put the facts of the case as well as the law, the legal argument, citing case law, sometimes using exhibits, sometimes using testimony from a hearing. And then the judge gives the other side an opportunity to respond to that. Usually that's the prosecution. They'll put in what's called a memorandum in opposition, which means they're opposing our position on that and telling the judge why they shouldn't grant our motion to suppress the evidence. And then sometimes the defense gets a chance to do what's called a reply memorandum, where we get to respond to the prosecutor's argument. So then it would go defense memorandum, which means our written argument, then the prosecution brief, and then a defense reply to that brief. Once the judge takes all of that information the judge reads through everything, and then the judge will issue what's called an order on those arguments. And an order is the judge's written decision about this. It can be appealed later under some circumstances, but that's for another video. But the point is that sometimes the judge's order can grant all of the arguments that the defense raises for you. Other times the judge can reject all of the arguments, of course, and then sometimes we get kind of a hybrid decision where the judge will grant some of our suppression motions and deny others. So I might be bringing a motion where I'm asking the judge to suppress the information from a search of a phone that happened without a warrant or that was an overbroad search warrant or something, and the judge says, yep, that was a bad search of the phone. I'm throwing that evidence out, but I'm denying the defendant's motion to suppress the statements that they gave to law enforcement, and I'm going to keep their statements into evidence. And so that can be where some are granted and some are denied. Okay, so that's what briefing is about, and that's how judges make decisions on briefs in suppression motions. There are other kinds of briefs. There are trial briefs, for example, briefs on other kinds of motions, but that's the most common type of brief in a criminal case. There are sentencing briefs as well. If somebody's sentenced and we're arguing about why they should get a lower sentence than the law calls for, and the like. The judge orders a decision. Here's an example of an order I received from a judge granting defendant's motion to suppress. So there's an order granting the defendant's motion to suppress. That was a case where I argued that there was an illegal search warrant that gave law enforcement permission to go through my client's whole phone, and I said that was way overbroad. They didn't have a right to go through the whole phone. If anything, they should have only been able to look in one particular place, one particular file or app on the phone, but they went through everything. They found evidence allegedly of another crime on the phone, and they charged him separately for that. But we argued again through a brief and a hearing in a motion to suppress that was an overbroad search warrant, got the search warrant thrown out, got that evidence thrown out, and got that case thrown out. So that's how briefs can play into that. If you have more questions, I'm criminal defense attorney Ryan Pasiga. You can call me at 612-339-5844, or you can find me at arrestedmn.com.